Move to, this case has been about chats, flirtatious chats from you or from the complainant, depending on the number. But I think largely the head issues have been about the 14th of November, 2022. The so-called incident, indecent incident. The second issue is about you allegedly sending a picture of your private part. Those are the two head issues that have covered what you are and what you are alleged to have done. Would you deal with the issue of the 14th or the 15th and its history and the indecent incident as it is alleged, so that we get over this once and for all, from your words, from your own mouth?
Chairperson, I would not love to look down upon the functionaries that couched the charge that I'm facing here, which relates firstly to whether the chats that were shared between the complainant and I were wanted or unwanted, which in my view is an important issue and at the heart of these proceedings. But additional to that, there's the issue about the 14th, or call it 14th or 15th November, which is something that I've had to endure. I look at it as a campaign to shame me. It is lies. It never happened. The complainant knows, much as I do, that it never took place. Now I'm going to take this tribunal through a pathway before I deal with the answer, pertinent answer. Did you do that which you have said we have done either on the 15th or 14th? I need to take you through, Chairperson, documents. Some of the things that I'm going to refer to are known by the tribunal, but context is very important. I wish to put things in their proper perspective before I deal pertinently with what happened that affects me on the 14th and the 15th. The starting point is that nothing of the sort happened, and yet this has brought much pain. I do not mind being accused of things I did, but not things that I did not do. This goes for the event or incident of 14-15 November 2022, and the pictures of the private parts that I'm said to have sent to the complainant, which is a lie. I will deal with this thing about pictures separately. Now, may I be allowed to deal with 14-15?
Can I ask you this question? Is it 14 or 15 November? In terms of what you are accused of, what exactly is the date?
I will answer that question in the course of what I'm going to present. It suffices for present purposes that I am still at a loss. I'm at a loss because it never happened. I'm also at a loss because from the complainant's camp, it's either 15 or 14. I don't know why, but I'm going to deal with that. Chairperson, I can't help but refer you to page 10 of the document. Page 10 of the bundle. And I must say, in my view, this thing about 14 November is not only false, but with due respect, it is malicious, and it is being pursued by the camp on the other side to shame me. I'm going to demonstrate this before I answer pertinently. I've referred the tribunal, Chairperson, to page 10.
Yes.
This is the notice in terms of Rule 4 of the Rules Regulating Procedures before the Judicial Conduct Tribunals, 2012. It's addressed to me, care of my attorneys of record, which indeed I received at the opportune stage. Now it says, with reference to the notice of hearing before the JCT, which is this tribunal, which is served on you along with this notice, the following information is provided in terms of Rule 4 of the Rules Regulating Procedures before the JCT 2012. Number one, it is alleged that the facts set out in Annexure A to this notice constitute a complaint of incapacity, gross incompetence, or gross misconduct against you. I'm not going to quarrel with the person who crafted this insofar as it refers to incapacity or gross incompetence. I choose not to delve into that. But for the sake of caution and completeness, I did say something when I started testifying. But let me focus on gross misconduct on the basis that I am said to have done something. Let me read further. Then it says, a concise summary of the evidence and any other information which substantiate the complaint against you is set out in Annexure B. So Annexure A, if you go to Annexure A, it is the complaint by the complainant. That's Annexure A. Annexure B is actually what one would term a charge sheet. And I'm not going to deal with interpretational issues. I'm simply going to go straight to it. It says concise summary of the evidence. It is alleged that between 2021 and November 2022, you sexually harassed the complainant, Ms. Andiswamengo.
Just a minute, page 26.
Oh, sorry. I got carried away. Sorry, Chairperson. Page 26. Small 26.
We are there now.
Thank you. Now, we are there because the summary or substantial facts are that I sent her on WhatsApp messaging service unwelcome or unwanted messages of a sexual nature, as well as crude pictures. And then I behaved indecently towards her in my office at the High Court in Umtata. I pause there. Let's go back to page 10. With your permission, Chairperson. Page 10, paragraph C. A copy of the following documents: the WhatsApp messages and statement of Acting Deputy Judge President Okota, which are to be presented to the tribunal, is attached as Annexure C1 to C43. We now know that when the complaint was lodged, a bulk of documents did not serve before the JCC or the chairperson of the JCC. At the opportune stage, I will place before this tribunal that document, which on its own shows what did not serve before the JCC. By now, we have a clue or an idea. Then it proceeds at page 11 to say, a copy of the video footage on 15 or off 15 November 2022 depicting the area around your office at the High Court in Umtata, which is to be presented to the tribunal, will be forwarded as soon as it is received. So those who set in motion this process, the process insofar as it relates to the tribunal, not the JCC or the JSC, the process insofar as it relates to the tribunal, in their wisdom, couched things in the manner they did. But then, Chairperson, could we go to page 21? Because we are told that this complaint is enshrined in the complainant's affidavit. So page 21 is part of the complainant's affidavit. At the moment, I'm not going to be highlighting things that relate to the complaint in its broader sense, but I'm dealing purely with 14 and 15, 14 or 15, 15 or 14, whatever the case may be. Paragraph 20. Painful though it is, I'm going to read this paragraph line by line. It was on Monday, 14 November, me, called me to his chambers and asked me why I am wearing colorful clothes when it is a court day. I told him I'm not going to court, but my colleague is. He said he was concerned about me. I was concerned about the decorum and not saying that my clothes were not appropriate. This is the complainant telling everybody, the world over, the universe over. He said he was concerned about the decorum and not saying that my clothes were not appropriate. That was not offensive, I must say, and I was not the only one present on that day. I paused there. And sorry to have to digress, but I will quickly return to the substance of my presentation. Today, the evidence leader has got the audacity, with due respect to her, to say that, among other things, I am being charged for ridiculing the complainant among other things, because of this event of the 14th. Chairperson, I'm just dealing with the 14th, and what I'm highlighting is that that was not offensive, I must say, and I was not the only one present on that day. That is what happened on the 14th. So what happened on the 14th was the interaction between the complainant and I and my secretary and Ms. Kukushe, who was in the office. We know now, according to Ms. Nkai, what happened. I have yet to deal with that. Then the complainant says a day later can only be the 15th. He sees me walking down the corridor and imitates how I walk. I didn't comment, I walked past instead. On my way back, court floors in Umtata is tiled, so you ought to hear who walks past if you know footsteps. He knew my footsteps, I don't know why and how, anyway, and he stood at the door and calls me in. He stood at the door and calls me in. I noticed that his secretary was not in her office. Got in and he showed me his trousers and said, "Do you see the effect you have on me?" The question that followed was, "Awufuna uyimunca," loosely translate, don't you want to suck it? He unzipped his pants and attempted to draw his erect penis, and I ran out of the office. I went home and thought about what had happened, then decided that on the following morning, I will tell him where to go off and so on. Now, we have heard it said, even in the broad context of civil proceedings, that, and I'm just talking law in the broad sense, insofar as the law, and everybody who is a lawyer knows this, that a litigant is not entitled in their pleadings to point somebody to a particular cause of action. And then when the trial is pursued, pursue it from other facts altogether. I don't want to be quoting case law on that, but I'm just mentioning that the affidavit that forms the fons et origo of this complaint tells us that something happened on the 14th, not offensive. Day later, on the 15th, something happened, allegedly happened, and it is what I've read. It pains me to have to read it. I hope I won't have to do it again, in the sense that as I'm presenting, I've got to talk about it. So this is what we are told in the complaint. 14, this is what happened. 15, this is something else that happened. In circumstances where we know, according to the complainant, he had been to the OCJ at some point, he was assisted in crafting some affidavit, he was afforded the opportunity to rectify certain things, and this is what we have. I am said to have done something on the 15th. Chairperson, I did not do it. Could we go to page 88? At some point during the day on 14 November, I was in my secretary's office having a chat with her. My secretary's colleague, Ms. Kukushe, was also present. Insofar as I was called upon to meet this case, this is how I dealt with it. Before the JCC, we saw Ms. Mengo the three of us walk past the door of my secretary's office. I called her and she stood approximately a step past the doorway into my secretary's office. She was not wearing the usual black and white apparel used by judges' secretaries. So I commented in jest about her dress code. I normally comment about the expected dress code in the courthouse. This has been the position since my days as counsel. The world over, let me say the country over, those who have interacted with me know that this has been my style. Those I was with at St. John's College, those I was with at the University of Transkei, know that I may be a bit pedantic about how I appear. Maybe that's why I'm called cute Londo and so on, something I'm going to deal with later on. I'm just mentioning this because I'm saying this has been the position since my days as counsel. I could call 100 witnesses to come and say, JP is very particular about dress code. And if I were to be asked why I'm particular about this, it's got to do with the fact that Sometimes standards dwindle with how we appear. I don't want to talk about departments and health department and how nurses used to appear and so on and so forth those days when we grew up as boys. But I just had to pause here. 37.4. Understanding the spirit in which this was said, she jovially responded that she was not doing court work on that day. She left being in a good and jolly mood. This was on Monday. Beyond this, Chairperson, I never interacted with her again. All I got was this complaint in the course of time. So I'm dealing with the 14th. Everything that I have said ties in well with what the complainant says in her affidavit, founding the complaint. Then let's deal with 15. On 15 November 2022, from the time I arrived in my chambers around 9 until I left around noon, I had no interaction whatsoever with Ms. Mbenenge. I say that under oath. I had no interaction with Ms. Mbenenge on the 15th. The only time I interacted with Ms. Mbenenge on the 14th is what is common cause from her complaint and what I have said in answer thereto. Chairperson, could we move to page 101? Page 101 is part of a document headed Request for Further Particulars for purposes of preparing for an inquiry conference. Then page 101. To enable the respondent to prepare for such inquiry conference, which will be held, and with a view to clarifying issues for determination at the hearing.
Chair, can I take you, JP, back to where you were? Because you didn't finish that. At paragraph 89, page 89.
Page
89.
Oh, page 89. 89.
Yes. Paragraph 37.6.
Oh, yeah.
I would like you to deal with that aspect because
Thank you for reminding me. This is me in an affidavit filed to defend myself before the JCC, before the matter was referred to this forum. It should be possible for the CCTV footage of the events of 14 and 15 November, to which I believe will bear me out, to be obtained. I was just expressing a view on the understanding that all is well, and I believe all was well until something that I can't testify to may have happened or may happen, but I would like to go back to page 101, if you allow me. At paragraph, and I'm reading paragraph 1, Chairperson and members of the tribunal. At paragraph 20 of the complainant's complaint, the complainant alleges that on 15 November 2022 at his Umtata High Court chambers, the respondent called the complainant to his chambers, unzipped his pants and attempted to draw his erect penis, and the complainant ran out of the office. At what time, this is the request for particulars. At what time on 15 November 2022 did the alleged incident take place? Time is of the essence, Chairperson. You can't have something like this befall you or beset you and not know the time. We know that it is said to have happened on the 15th under oath. At what time did the complainant leave the court building after the alleged incident on the day in question? And then what are the details, the number plate, the model type of a car, whether it was hired or state vehicle or vehicle used by the complainant on 15 November 2022? What are the details? This information will be furnished to track the movements of the vehicle on the day. For the record, the respondent's vehicle on that day, on the day in question, was a white BMW X5 with registration letters and number JJL482EC. Chairperson, let me pause. These proceedings are inquisitorial. The officer leading evidence is not a prosecutor in these proceedings. She is officer leading evidence. That is why, in your wisdom, Chairperson, at some point you had to ask, are you going to lead your own witnesses or are you going to leave everything to the evidence leader? It must have dawned in your mind that the inquisitorial system is not something that most of us are au fait with. Well, let me say in South Africa in particular. And we've got my learned colleague, the evidence leader. I call her colleague because she's a lawyer. So this information is sought. Why? Because it is incumbent on the officer leading evidence to to conduct investigations, not to be partisan. She is told that Mbenenge was driving, by my attorneys, Mbenenge was driving a particular vehicle. Reach out and get tracking reports so that we bring this information here. Whether that happened is something that we are going to deal with shortly hereafter. Further, the respondent requires full-day video footage of all entrances, front and back, and passages at the Mthatha High Court building on 15 November. Let me end there. There's a lot of particularity that was sought, but I choose not to read everything. I choose to read that which I believe relates to what is important. Then, Chairperson and honorable members of the tribunal, at page 105, this document is very important. It is of significance in that it is a decision taken by the tribunal in relation to issues that were raised by my attorneys, directed, among others, at the officer leading evidence. Number one, a pronouncement is made. Because we were seeking particulars, those particulars were not being furnished. One, the respondents request that the complainant states the time of the alleged incident of 15 November 2022. Let me read the pronouncement. The complainant is required to do so, to do as requested. If she is not able to give the exact time, she is required to give the approximate time, or at least say whether it was in the course of the morning or in the afternoon of that day. This information must be given to the tribunal secretariat as well as the respondent's legal representative within 7 working days of receipt hereof. The fact that it was not furnished within 7 days is nothing that I will make moment of. Then paragraph 2 relates to the footage. The tribunal will, in collaboration with the security company concerned, as far as possible, arrange for the holding of the above identification parade comprising security guards who were on duty on the morning of 16 November, being the date on which the complainant says she was told of the deletion by one of the security guards when she arrived at work that morning. Something has been said about deletions, obliteration. At least we know where we are, that evidence has disappeared into thin air. Chairperson, let me not argue the case. It is in the hands of capable lawyers.